Welcome to Divorce TV. I'm your host, Wally Marcus. I've been a divorce mediator for about 25 years and have enjoyed doing this TV show. And our topic today is divorce and property. And my very special guest is a good friend of mine, Robert Michael Hersch.
Hello, Wally.
Welcome.
Thank you very much.
And this is, I was telling you as we were talking before, you're the first guest we've had who's 3 times. So keep trying, we'll get it right.
Yeah, it's been quite a while, but I'm looking forward to it.
No, it's good. You did the show on collaborative, you did the divorce on just general introduction, and now we do property today. So you're always a great guest and a lot to do with it. But for the people that have not seen the other shows, do you want to tell them a little bit about yourself?
Well, I'm an attorney in private practice. I have been in private practice since 1988. I handle a pretty wide range of civil matters, including divorce, collaborative divorce. I do divorce mediation as well as you. And I handle other civil matters, business and some real estate. That's
good. I know I've had problems periodically. I check with you, and you've always been very helpful for me as a transplant. We're talking about property today, and I know it's sort of a basic question, but what is property?
Well, property is obviously anything that's can be tangible, it can be intangible. You know, basically in divorces you're talking about bank accounts, money, real estate, personal property. You even get into situations about pets and retirement accounts. It's a pretty broad range of assets.
What's the difference between personal property and real property? It seems to be an obvious question, but for some people I guess it's not.
Well, and it makes a difference in the law too. Real property is real estate. It's where the title to the asset, whether it's a home or land or a business, a building, is conveyed or transferred by a deed. And other property would be, bank accounts or motor vehicle, cars are done by a different kind of a title.
We're going to allude a little bit to debts because debts have a sort of a similar quality to property. They're not property, but they sometimes treated similarly that way. Right. What are debts? Or once again, I know it seems obvious, but
so debts are the obvious things of credit card debts, your mortgage, money you may owe anybody, anything that you have an obligation, a financial obligation to, whether it's a lending institution or a friend that's lent you money, or any other money you've borrowed, anything like that is
and the reason is, we obviously do this is that in divorce cases, one of the always 3 big issues is support children and dividing up assets and debts, and so this is an important part. So what are marital debts and property?
Well, I mean,
in Arizona, I guess that does vary.
Well, in terms of what gets divided or what has to be addressed in a divorce,
or what's considered, what is there all property marital property?
Well, no, there is a presumption in Arizona that the property that's been from the date of the marriage until you have filed a petition for dissolution or a petition for legal separation, there's a presumption that everything that's accumulated, whether it's earnings, it's retirement accounts, it's real estate, it's presumed that it's community property. And the same thing with debts, that whatever debts are incurred during the marriage, it's presumed that they're community.
When you say community property, what do you mean by that?
So community property, there are 9 states that have community property laws in the United States. I actually made a little list, or have a list of them. Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. So it's a separate set of laws that deals with the accumulation of property or debts differently, somewhat differently, than non-community property states.
And the significance when you're getting divorced is what?
So when you're getting divorced, you're looking at what earnings have been, what money has been accumulated during the marriage, where it's been deposited, and debts that have been accumulated during a marriage. Now, not all of the money that's accumulated during a marriage is community. You could, for example, have a gift. Someone may give you money, or you may have inheritance where you inherit money from a parent or an uncle or an aunt. And as long as you have put that money into a separate account and not a joint account, that remains your separate property, and it's not to be divided during a divorce.
And what about property that you owned prior?
Property you owned prior is the same kind of analysis. As long as you haven't taken, let's say, for example, you had a home. I have had several of these kind of cases. Let's say you had a home before the marriage, and you did not retitle that in your new spouse's name and yours, it remains your separate property.
But if you ended up taking with a bank account and you put it into a joint account,
there's a presumption. Yes, well, it's a presumption if you put a spouse on the title or you put it into a joint account after you get married. There's a presumption that you intended to make a gift to what they call the gift to the community, which means a gift of half of that to your spouse. And you can argue against that. We call it rebutting the presumption that you did that for some other reason than to make a gift, but it's a difficult argument.
If there's property that is community, okay, and you want to I don't know what the word is, make it no longer community property. Is there a way of doing that?
Yeah, you can do what's called either a premarital agreement, or you're really talking about a postmarital agreement, where you can do a written agreement between the spouses and say that you are not going to be bound by the community property laws of the state of Arizona.
Can you use specific property or just across the board?
You can do anything you want with it. I mean, there is a statute that deals with premarital agreements, and most of us think that the courts would look at postmarital agreements as long as each party had an attorney and they understood what they were agreeing to. That's a big issue.
Yeah, the classic case with prenuptials.
Yeah, it's a big issue that the courts will generally not enforce premarital agreements or prenuptial agreements, same thing, or postmarital, unless you can show that each party.
So there is a risk at that point if you want to convert something to community to non-community property that somebody might interpret it as not being converted.
Yes,
okay.
I think so.
There's other ways. We were talking. This goes back to the law school. Actually, in my property course, there's different ways you can own property. I mean, there's community property, but there are different ways you can own property as well, which I think confuses a lot of people. Survivorship, non-survivorship.
Yeah. Well, during a marriage, and when you say own property, you're talking about the way the property is titled. So typically,
the and or the
right, like with motor vehicles. The easiest way to think about it would be with real estate. You can own property as in your own name, where the spouse would disclaim an interest. You can do that. You can own property as joint tenants with right of survivorship, which means that you own an undivided 1/2 interest in that property, and when the first person passes away, then the survivor owns the entire property. You can do what's called community property with right of survivorship, which has that same survivorship aspect. If one party passes away, the surviving spouse owns all of it.
What's the difference between those two?
Well, the community property with right of survivorship, you have to have a marriage. You have to have a marriage to have it be community property with right of survivorship. You could have joint tenancy with right of survivorship with your parents, with your friend. It doesn't have to be a marriage.
So it's basically the same thing except you're
same
married.
Concept. There is a difference when the first person passes away. This gets a little technical. That what we call the basis, or what you've paid for the property, gets stepped up, or it's reassessed at the value at the date of death, and so it can be helpful for tax reasons.
Sure.
You can also own property in what's called tenants in common, with either a spouse or typically with a friend. Like if you went into a partnership with a friend to buy property, and you wanted to each be able to will your half of that property to somebody else, you would own it in tenants in common.
Can you do that with a spouse?
You can do that with a spouse. I don't see why you couldn't do. I don't know why you would want to, but if there was some reason you.
Well, where I've seen that come into play, strangely enough, is sometimes is in divorce cases where the parties continue to own a house, and particularly in this market where the houses can't be sold, is whether you continue owning a house. Parties get divorced. I mean, you tell me, parties get divorced and they continue to own a property together. What happens to the? Well, and it's in both names.
Again, they're not married anymore, so they're not going to own it in community property with right of survivorship. More than likely, most of the times, if they're going to continue to own it afterwards, they're going to want to own it as tenants in common, because they're going to want to be able to gift through their will or a trust their half to someone else. Now that also gets pretty complicated because the former spouse is also a half owner, and so the children may not want to be half owners with the former spouse.
They could do it in survivorship at that point. If they still, even though they were divorced, they could still.
You could. You can't do community property with right of survivorship because that requires a marriage, but you could do joint tenancy with right of survivorship. And there are people that get divorced who still get along great and have children together and make agreements during their, whether it's typically it's not going to be a court situation, but if they're negotiating a mediation or a collaborative divorce, they say, I'm going to continue to own it as a survivor benefit.
And with the mortgage, at that point, that's why I think a lot of parties get confused is what happens with, they'll transfer the property in a divorce case, and what happens to the mortgage. property. You have a $200,000 house, $100,000 mortgage. It's in both the parties. It's community property in both names. They get divorced, then we'll say the wife to now own the property.
Well, again, the mortgage is still there, and the bank, the lender, is not a party to your divorce. So they just want the debt paid off or continue to be paid. So that has to be addressed in a divorce. If you're going to continue to own it, who's going to be responsible for the mortgage? Are you both, or are you going to try to buy the other party out? That's what we try to do. And when values were increasing, as they were until a few years ago, it wasn't that hard to get refinancing. One spouse wanted to keep the house, or say they both agreed that the husband or wife was going to keep the house. And so long as the party that was going to stay in the house was working and had a good income, they could generally refinance it in their own name. Well, not generally, sometimes, and take the other spouse off. But not so easy anymore.
No. Let's talk a little bit about, to get down to the nitty-gritty here. What happens? Okay, people have property, some communities, some separate. They go get divorced. You said the community now ends when the paper's been filed. What happens? They have a house, they have a car, they have bank accounts. What's happening to this property? Some of it's community, some of it's not community?
Well, the divorce decree is going to set out who's going to own what property as much as possible. The kind of scenario that you were talking about where they're going to continue to own the house after the marriage is not very common. Because, you're getting divorced probably for a reason that you can't get along that well, or you don't want to get along that well anymore. So you don't want to set up a situation in a divorce decree or a property settlement agreement where you're going to be owning property together. I
was asking a little bit more is how do you, in a contested sort of a situation where the parties do what they come in, they have, this is all the property that we have.
Right.
Who gets what?
And how is that figured out?
Yeah. Is there some?
Well, the way that the
I guess what I'm asking really is the community property affected separate property if they have things? How is the ownership of the property or how it's owned affect how it's maybe divided if it's between the parties?
Well, the divorce statutes talk about dividing the community property or the joint property equitably. That's the phrase. And so I think that's why we're such proponents of mediation, divorce mediation, or collaborative divorce, because it gives you if you do it in a negotiated setting, you can do whatever you want, whatever works for you, and it might not be absolutely equal, but it may work for the parties. If you're going before a judge has an obligation to divide the assets and the debts equitably, which is as close to equal as the judge can figure out how to do.
So if they were owning community property, they own the house might be divided. Are those fairly equally 50-50? Property which was in one name, separate inherited property, something that came in prior to the marriage?
Well, that stays with that spouse.
And the divorce can't touch it.
That's correct.
The judge couldn't order, but the parties in a mediator or collaborative could
do what they wanted to. Sure, if they felt that they wanted to do a transfer of some separately owned property to make things even, and even though technically it might be separate property, they might consider that it's something they should divide, although they're not legally obligated to.
One of the ones that we talked, I think you alluded a little bit to the pension plans, and I think that's always interesting. If you have a 401k or something, let's say that you've contributed to prior to the marriage, and then you contribute during the marriage, what happens with that? And that's property which seems to be one piece of property, but...
Correct. So what you have to do is you have to figure out how much money has been contributed to that 401k or whatever the retirement account is, 403b or whatever, because the division of the assets, when I was talking about equitably, is only the assets that have been accumulated during the marriage. So let's say that 5 years before the marriage, money was put into a 401k for the husband. Well, the wife is not entitled to half of that first 5 years. She's only entitled to half accumulated during the marriage. So it's important to figure out that difference. Yeah.
On that one. It was interesting on that one. How is the property transferred around? Once we've decided it, they have a house, what happens? It's once again, these are fairly obvious questions for you and I, but I think for the general public it's not. What happens?
Well, at the same time that a divorce decree, once it's negotiated, assuming it's negotiated, or a judge makes these decisions, then a deed, if, for example, one of the spouses is going to take the house and either get bought out, you just prepare a deed. We do a quitclaim deed. Typically, we do what we call a special warranty deed, which is pretty simple, and it just, the spouse who is no longer going to be the owner will sign off that deed, which gets recorded with the county recorder, and then the other spouse will be the full owner. You still have the issues of the mortgage, and how is that going to be addressed?
You talked a little bit interesting before about basis, and I think maybe it's interesting to come back. In the divorce case, they have the house, they transfer. You were talking about the stepped-up basis when somebody dies, but what happens when that property, a couple owns the house together? Is the basis at the time of the divorce, when the value at that point, or is it the basis at an earlier time? How do you figure out what?
Well, again, the basis issue is really only to worry about when you're selling the property, because you're looking to see if there is any gain that would be taxable, and so it's not really a major concern during a divorce.
Well, the other thing I guess we were talking about in the divorce case, which comes into, is how do you value all this? I mean, if somebody has a house, go on Zillow, or what's the?
Well, a lot of people are using Zillow, which for people who aren't familiar, it's an online service that is free, as far as I know, that you can go onto Zillow.com and it gives you what it thinks is a value for your house.
I wish they'd buy it. I looked at some of my values more than what I sold them for.
So what we typically do, if we're not going to become, sometimes people are okay with that. What we typically have done before we had services like Zillow is to get an appraisal. And there are property appraisers in Tucson in every city who you pay, and it's not that expensive. It can be anywhere from $300 to $500 to go, and they look at all the comparable sales in that area. They look at your house, comparable sales meaning houses that are similar to yours, and what have they sold for in the last 6 months or a year, and they come up with what they feel is an appraised value.
You started talking about a lot of these people now are underwater on the property.
Yes.
So what's your sense of what do you do at that point?
Well, it's very tough. I mean, what people are trying to do, obviously, is sell it or maybe do a short sale where they're trying to find a buyer who will offer less than what the bank is owed. And then the short sale idea is you go to the bank and try to convince them that this is a good deal for them and they should accept that lesser offer, and then absolve the parties from any further liability under that loan.
Do people reach a point sometimes where they hold on to the property?
Sure.
I finally just mediated a case where the people were going to hold on to the property until such time as the value reached the value of the mortgage.
Yeah, and people are doing that more and more now because they owe more money than their house is worth because of the sharp decline in values over the last few years. And particularly in a case where it's paid off, and maybe they can rent it, they will agree, let's just hold on to it for a couple, 3 years. And again, hopefully there are parties that can get along pretty well and figure out when's the time to sell, when's not the time to sell. And then they wait until hopefully I'm sure the market's going to come back. It's just a question of when.
We haven't discussed too much about debts, but basically the debts are going to be handled, it's almost like negative property, I guess. Is it handled the same way?
Well, what happens in a divorce or a legal separation, which is the same dynamic, is that you're figuring out who is going to take what debts. So again, the creditor, like a credit card, whether it's Chase or Bank of America, they don't care if you're both on the debt. They don't care which of you take it. They want it paid. But you make an agreement between the spouses, I'll take this Bank of America credit card, you take that Chase credit card, and you try to equal it out so that the division of assets and debts, again, is equitable. What sometimes happens is that one of the spouses who said, for example, they'll take the Chase debt, doesn't pay it. And then what happens? So again, the bank's going to come after both of you. And then one of the spouses will have a claim against the other for not abiding by the divorce decree.
And if one files for bankruptcy?
Sometimes it forces the other one into bankruptcy. Yeah. So the bankruptcy will discharge, depending on the kind of bankruptcy it is, will typically discharge that debt to the credit card company.
We discussed some of the questions,
but only to the party who filed bankruptcy.
We discussed a lot of stuff in advance, but every once in a while something else pops into my head. I was just curious. Well, the statistics are now more and more people aren't getting married but are living together. That's not going to be obviously that's not going to be a community state. What happens in a situation where you have a couple living together, have a kid, everything else is they're just not married?
Yeah.
And they're buying houses, they're buying cars.
Well, there's more and more law being made in this area now, and I think the way the courts are looking at it is to try to do the same equitable division of the assets and debts.
But it certainly wouldn't be community at that point.
No, it's not technically community because you don't have a valid marriage. But how else can you look at it? Some people, if they're smart, will do an agreement. Will have an agreement between them.
You're not a romantic.
I know it's not so sexy to have a premarital agreement, or if you're not getting married, to have an agreement. But it really helps to say, how are we going to do this? If the marriage doesn't work out, how are we going to address this? And it would really be better, if you're going to do that, to say we're going to look at it similar to the way divorce statutes are, or some other method.
Given
spousal maintenance is another thing that people need to can talk about. Is there going to be what we call spousal maintenance is alimony? Is there going to be alimony if the marriage doesn't work out? And that's frequently a subject of premarital agreement.
We were just recording this show in May, but it's not going to be shown for a few months. And President Obama just announced his position on same-sex marriage the other day. And I guess in Arizona we don't have that. But in the states, I don't know. What's your situation? You think in a state where they had a same-sex marriage, would it change anything at all?
They permitted it?
Or if Arizona did allow it, I would assume it would be the same. It would be the same.
It would be the same. I mean,
it
would mean, and that's what it is. It means that you're getting married, and then you have the same rights that other people have that are getting married, whether your spouse is of the same sex as you or not.
Although I guess it's in some ways it's the same way we're talking about couples, heterosexual couples living together, but not getting married, and that would be very similar to a same-sex couple living together.
Well, except for the fact that if same-sex marriage was illegal in that state, you would be in the same position as a man and a woman that got married.
One of the questions that seems to come up is the sort of tangential or property cases that come up a lot is where people are contemplating a divorce, and people say, if I move out, am I going to affect my ownership of the house?
No, absolutely not.
But that seems
you're still on the title, you're still a half owner. Now, other issues may come up about who has the right to stay in the house if people aren't getting along.
How is that handled? I mean, that sums up. Seems to be in a lot of cases I handle. Matter of fact, very often what ends up happening, a couple comes in, we're mediating, we resolve the issue of who's staying in the house, and then that's all they're really concerned about. Then sometimes you never see them again.
Yeah, well, because it's a day-to-day thing if they're not getting along. Hopefully they can work it out the way you're suggesting in mediation or in a collaborative divorce. And the courts are available, and there are a lot of cases that come before the court commissioners and judges in Pima County that are just this issue, what are called temporary orders. Before the divorce is final, but after a petition for dissolution or legal separation is filed, who's going to live in the house if they can't agree? Who's going to pay the various community debts? That needs to get worked out, or have a judge decide.
So if one of the parties wants to stay in the house, they want the other party to leave, once again as part of the divorce action, they would have if they couldn't agree on it, they'd have a judge decide.
Yeah.
It was at that point.
Yeah.
And once that happens, because this comes up a lot too, can that person who's been forced out just come and go as they please?
No, if you have a court order that says that one of the spouses has a temporary order in favor of that spouse to stay in the house, then the right to possession of that home, not the ownership, but the right to possession, to come and go, change the locks, is with the party who the court gave it to.
Does that make any difference if it's community, not community, or if the house? I mean, let's take an example which may be extreme. Husband owned the house prior to the marriage, kept it separate, not community. Couple now gets divorced. Wife wants to stay in the house. Can she stay in the house even though it's technically the husband's house?
Yes. I mean, the judges are, when you're having issues of temporary orders where the petition for dissolution or legal separation has been filed and the divorce isn't final yet, then the judges are really trying to maintain the status quo. They want to keep peace, they want to keep some order, they want things to calm down so that the case can get worked out. So it may be that if they've both been living in a house that technically is owned by one of the spouses from before the marriage, the judge may very well say, let's just keep it the way it is right now until this gets worked out.
I actually had this happen, but I'm curious of your thoughts on it. Get divorced, they want to stay living together in the house.
As long as World War III doesn't erupt, that works out great. And a lot of people are able to do that. Some people are able to do that.
I think especially with the houses underwater now, sometimes that they...
And there's, most houses have multiple bedrooms and people can live in different parts of the house and just, get along like roommates. That can happen.
Let's talk a little bit about the sale of the house. The different situations that could potentially come up with assuming that there is enough equity, they can sell the house. What issues or problems come up with sale? If the parties agree on it, I assume no problem.
They can do whatever they want if they agree on it. I mean, issues come up with you've got to pick a listing agent. If you're going to list it with a broker, you need to agree on the listing agent. You need to agree on the listing price. and you need to agree as offers come in, which are likely to be much less than the listing price, what are you going to do?
I keep hearing the word agree. What happens if we don't agree?
Well, if you don't agree, then you try to work it out in mediation or collaborative divorce, or you may end up in front of a judge again with a temporary order. A judge could say, you're getting, if you know what the appraised value is, or a comparative market analysis from a real estate agent, the judge may say if you get an offer at that appraised value, or maybe 10% less, that you have to accept it.
What about repairs and maintenance and all these other things on the house?
Same kind of thing. I mean, you're looking at what the income is of the party. How much is the husband making? How much is the wife making? Who's living in the house? Who can afford to make the repairs? A lot of times what we do is in working out agreements in mediation or collaborative cases, we typically try to encourage people to say, whoever's living in the house will take care of most of the expenses under a certain amount. So say the house, the roof falls in, or something major happens, or there's a storm, it's going to be over the amount of money. So we may say anything under $500, the person living in the house will take care of repairs. Something more expensive to repair, then you both have to share in it.
It just occurred to me, sort of jumping back a little bit, but what happens if the couple really both want the house and they can't agree? I mean, is there any sense?
There's nothing else to do, but a judge will order it sold.
You think the judge wouldn't order it being to one part or the other? They'll always, most of the time, will order it.
I guess that's a judge could do that if there were enough assets, whatever the equity is in that house. If the judge could find another asset to give to the other spouse to balance it out, the judge could do that.
We have about a minute and a half left, so we're getting close. But I mean, one of the issues that I see come up a fair amount is children still in school.
Right.
They're in the school district. They're in a good school district. She wants to stay in the house. She's saying, "I want to stay in the house because of the kids."
Well, again, that in a temporary order, a judge
permanent. I'm just saying, would they let her, stay in the house for any? Or I mean, and you may sort of contrast in our probably our last question. Contrast between mediation and an adversary case, whether there's any difference on that.
Well, I think there is. In mediation, you can do anything that you feel will work out for both parties as long as they both agree. A judge is much more limited. A judge needs to find a way to get the spouse who's not living in the house their share of the equity. And either way, the only way to do that is either sell the house or find another asset.
A judge couldn't order the one party to stay in the house and then have it sold when the youngest child turns 18 or something like that.
Geez, I think absent an agreement, I think that's problematic.
Anyway, I don't believe how fast this has gone.
It does go fast.
Really, yeah. We got it crammed in a lot in a very short period of time, but I want to appreciate you very much for coming. This has been fascinating. I always learn something. I love talking about divorce, and you've been watching Divorce TV, and our topic today has been property and all the ramifications of it and debt, and my guest has been Robert Hersch, our local attorney who does a lot of this in both mediation and collaborative. And Robert, once again, thank you very much for being my guest.
You're very welcome. That's good. Interesting.
Yeah, it's
causes you to think as different questions come up.
Yeah, it's yeah.